Good evening, ladies and gentlemen. Welcome you all to another episode of the Architects Discussion Forum, which is organized by the Sri Lanka Institute of Architects. Mr. Rajeev Amarasuriya is an LLB Honours graduate of the Faculty of Law in University of Colombo, a fellow member of CIMA UK and CIMA Sri Lanka, and a practicing attorney of law. Was recently named as one of the LNT CIMA Trailblazers for 2021. He is the incumbent secretary of the Bar Associations of Sri Lanka, the president of the Alumni Associations of the University of Colombo, and a board and committee member of several state and private sector institutions, including the Sri Lanka Accounting and Auditing Standards Board, the Standing Committee of the Legal Studies, the Sri Lanka Institute of Information Technology, the Sri Lanka National Arbitration Centre, and the Sri Lanka Cricket. He is also an executive committee member of the Law Associations for Asia and the Pacific. He was also a past commission member of the Securities and Exchange Commission of Sri Lanka. Welcome on stage, Mr. Rajeev Amarasuriya, for your presentation.
Thank you very much for that introduction. Vice President of the Sri Lanka Institute of Architects, ladies and gentlemen. First and foremost, thank you very much for inviting the Bar Association of Sri Lanka and myself to make a presentation before you at this important Architect 2022 exhibition. It is something we all as laypersons come to on an annual basis, and this time I'm fortunate here to be before you speaking a few words. The Bar Association of Sri Lanka, quite apart from being a comparative profession, your leading and most sought after architect, Mr. Jeffrey Baba, was in fact one of our members. And thereafter he, of course, came into the architecture profession. As I was telling your Vice President, architecture was actually an option for me, with something I thought I might do fairly well, sufficiently well at, but however things changed and I ended up doing law. But I have worked very closely with several of your architects. In fact, Mr. Lal Fernando is the one who designed our home, and at the moment I'm working on another small project with him. And he was my father's classmate, and my classmate Tilan Kottigoda is supporting me to construct a 50-meter swimming pool for the University of Colombo. It's a project hopefully we will start this year, and he's doing this completely pro bono for the university. So I must also mention that. When I was asked to speak on a topic of relevance, I thought a bit. We have hundreds of legal topics to speak on, but it has to be something relevant to all of you. And something, of course, I mean, lawyers are there, so you can retain lawyers, but something where architects as maybe professionals, as citizens, what is a law relevant to you? That is when I thought maybe I will speak on the right to information for several reasons. One is that it is a new law, a new regime. There is not too much knowledge on it, and it's something you as a professional, you as a citizen can make use of. And why I thought it is relevant to you is because I also have been involved in some matters pertaining to building construction, planning approval, and we have made use of the Right to Information Act and the provisions to secure information. And this is something which all of you can directly do. Because sometimes in sensitive areas, sensitive developments, sometimes, when there are complexities, sometimes there seems to be a lack of information in the regulatory framework, in approvals. Sometimes approvals are not granted. Sometimes different local authorities might have different standards. Some might say area space is 7.5 meters, some might say 10 meters. There is sometimes no uniformity, and sometimes it delays the whole process. I am presently involved in a small project which I'm doing with Mr. Fernando, and I found that a lot of information we don't have. We submitted, then they have changed the regulation, something has happened. And then, of course, so the whole project, I think, takes longer than it should. So I thought this is a apt topic to speak on, to explain to you how this right to information regime works and how you can make use of it in your professional work. So let me just take you through. Initially, conceptually, the right to information was brought in as a fundamental right, maybe you know, to the 19th Amendment to the Constitution in 2015. Every citizen shall have the right of access to any information as provided for by law, be information that is required for the exercise or protection of citizen right held by a state ministry, so on and so forth. So basically the concept is, you have a right to information, of course subject to certain legal restrictions, which is in public authorities. Say now you all work with the UDA, you all work with the local authorities, maybe the Coast Conservation, maybe there are several other institutions. Information which is in their possession, you might have access to under the right to information regime. Now that is important. This is, I will explain to you. Now, from time to time, there are changes in policy, changes in the way regulations are brought about. And sometimes there are periods when those documents don't come out. And sometimes you wait when you're doing a development project, doing architectural design and development. You have to wait because the officers also sometimes don't know. But they say there is a new law which has come, a new regulation, new policy. You have to wait. And sometimes you have to go by what they tell you. And sometimes you go down the approval process and then it's something different. So you, as a professional, as an architect, can, through the right to information provisions and regime, seek that information from those authorities legally. And without relying on somebody else to tell you how it happens, you might be able to look at that regulation, look at that circular, look at that decision, and decide for yourself whether your project is permissible or not. Now, a good example is there is now a certain area in this country which has been declared a natural, environmentally sensitive zone. Now, there is some dispute as to what one can do in that zone. And so we have made a right to information request with various questions asking what can you do, what can't you do. But there is, if you look at the document which has been provided, it's not clear. So let me explain to you how you can make use of this as a citizen and as a professional. So basically the Right to Information Act came into being on through Fundamental Right, and then it was enabled through Act number 12 of 2016. The preamble says to foster a culture of transparency, accountability in public authorities by giving effect to the right of access to information, combating corruption, promoting accountability, good governance, and so on and so forth. This is basically, it was a piece of legislation brought into after the amendment of the Constitution to give access to public records, to make things more transparent and make public authorities more accountable. Now, this is not something special to Sri Lanka. This is something which is evolving around the world. A lot of countries have these provisions. India is a jurisprudence which has developed a lot in this area. So that as soon as citizens have access to government information, then it's more difficult to do wrongdoing. Because if some decision, something is done wrong, or we always speak of, corruption, things like that taking place. But those all have to be, whatever happens has to be documented. And this act, which has come in, is still not being used completely, gives the citizen, you and I, the right to call for that information. And then if something has taken place which should not have, whether it's today, tomorrow, or in 10 years' time, that information you can get. And if someone has done something wrong, that would get picked up. So that is basically the concept of right to information and why it is within our system. So let us come to the salient features of these provisions. Section 3 provides, subject to provision of Section 5, I'll come to that. Every citizen shall have a right of access to information which is in the possession, custody, or control of a public authority. So there is a right, every citizen, everyone here has a right to access information which is in the possession, say take the UDA, if it is in their possession, in their cupboards, in their files, in their computer, or in their custody, or in their control, even in a subordinate office or some other, local authority. If the information is held by them, their custody, but somewhere else, then we as citizens, subject to certain restrictions I will speak of a little later, you have access to that information. The second important criteria is that it is information which is in a public authority. I can't write an information request to your vice president and ask for her plans in her file, because she is not a public authority. But I can write to the UDA, you can write to the UDA and ask for some information which is in their file. So sometimes we have in cases even got plans, because sometimes, especially in these condominium developments, often the residents around have issues. Drainage, they say, you have gone. This is actually important, because there are instances where plans don't really reflect the law. Sometimes there are areas, encroachments, built beyond the space. There are, percentages outside. Now, when that happens and say there's a complaint made, and say a citizen or through a lawyer, they seek that information, there are times when, say the resident, the neighbor, can access that plan. That's the flip side of it. As much as it is a beneficial, the next door neighbor might get access to your plan. And then all the neighbor needs to do is to compare that plan together with the regulations and then show the violations. And time and again, we have done that in court to show that the plans which are being approved or which are being constructed upon are in fact in violation of the regulation. And of course, then if you go down the line, then you as the architect who signs off also would be complicit in the process, because you should not sign off a plan very well knowing that it violates the regulation, which actually is a law. So when you say you violate a regulation, you're actually violating a law. So that's the other side of it. So coming back to making use of the right to information as a tool, what is information? Now when you say public authority information, what can you access? It's a very wide definition. Includes any material which is recorded in any form, records, documents, memos, emails, opinions, advices, press releases, circulars, orders, logbooks, contracts, reports, samples, models, correspondence, memoranda, draft legislation, book, plan, basically every conceivable type of information. Even I don't think you all submit samples, but say institution where you submit a sample, that also through the right to information one might be able to access. Then let us look at what a public authority is. My presentation goes into detail, but that is of course not for your consumption, but what you need to know is where you need to get access from. All you need to know is if it's a government institution, say like a ministry, authority, or agency of the government, then that becomes a public authority, and you can seek information. UDA is the obvious choice, the obvious institution which you deal with. And of course, for example, as I mentioned before, coast conservation, the local authorities, especially I'm sure you all may be having issues when you all go to local authority approvals, because as I mentioned, I will come back to that. I'm trying to construct something in Tangol, and then when we submitted, we were told to submit the plan to the local authority. Then the local authority, when the plan was submitted, then informed that no, now the jurisdiction is now with the UDA, with the new regulation. So then it has to go to the UDA. And the UDA says, well, we need to get coast conservation approval. So there's a whole process. And in that process, obviously, as you know better than I, it takes a long time. And of course, time is also cost and money. So sometimes that is because there is a lack of information. And maybe as the institute also, if there are areas where there are gray areas, you are not sure what the exact provisions are, circulars are, maybe the institute can get that information and share with the membership, if there are areas like that. So anyway, coming back to So basically, public institutions are those, public authorities. Then, I said at the beginning, you have the right of access to information which is in a public authority, but subject to certain limitations which you also need to know. The limitations are if it is personal information. So sometimes, if I go and ask, say, the Colombo Municipal Council or the Urban Development Authority, maybe on behalf of my client, or the client directly requests for a plan of somebody, saying, I want to see the plans, approved plans. The plan, you can ask for the plan, the preliminary approval, the final approval, the COC. I make that request. The Colombo Municipal Council can turn around and say, no, Mr. Amarasuriya, or whoever the person requesting, no, this is personal information. This is not information for you. This is information of somebody who has submitted a plan. Generally, personal information will not be submitted. However, the Act says that if the larger public interest justifies the disclosure of that information, then it must be released. So if I can show to the Colombo Municipal Council or to the UDA, well, this is not personal because it seems that there is a violation of the regulations, there is affectation to the residents of the area, there is problems with drainage, they have it built beyond the restrictions. The public interest overrides the individual interest, then there is opportunity to secure that information. So that is the danger. It is a positive, but the danger is that if there is some wrongdoing which has taken place, a citizen might have access to that information. That also must be kept mindful. Then there are other restrictions which are probably not too relevant to you. So I will run through that, but basically what is relevant to you, there are several grounds upon which information can be refused, but those are more relevant to different areas. But for you, it will be the private information, confidentiality. Then you might ask me, now I have told you about the right to information, all this. Now how does one make use of this provision? It's very simple. You can go to the Right to Information Commission website. The actual commission is located at the BMICH in the office complex. There is a standard form which needs to be filled. You can even write a letter, and each institution, each government institution by law has to have an officer called the information officer. And that name and contact details of the information officer is by law, it should be available on the website. So if it's the UDA, if you go to the UDA website, you will find the name and contact details of the information officer. You can't write to anyone at the UDA or the local authority. Then you can download the form. It's a 2-page form. You address your request to the information officer and you say, this is the information I want. The law specifically provides that you don't need to give a reason. So whether you're the architect or whether it's your client or whether I write or I'm a meddlesome busybody, the law does not require you to give a reason why you're asking for the information. So you can write to the authority and say, you are supposed to have made this decision restricting the rear space. I'm just taking a generic example. Or prohibiting the construction of buildings above certain floors in this area. Please provide to us the decision made and any circulars or regulations issued in that respect. Because as you know, it takes time sometimes to get the information out, but during that you can make a request. And the law does not require you to give a reason. So if you don't want to write it in your name, you can get somebody at home to do it who is not an architect. It doesn't matter. Of course, it is sometimes relevant to give a reason when this private information, the public interest aspect, you have to push. So if I'm writing and saying, okay, this building is taking place next to my house, and I'm asking for the plans, before they reply and say the private information, we can't release it, you can maybe say, well, I'm asking this because I have this fear that there is a violation of the regulations, there is an issue, and that is why I'm asking for it. So it is a simple process to request the information. You have to also say how you want it, whether you want it in the form of a printout or an email. The form is there. It's a simple form to complete. Also there is provision, you can also make a request by email to the information officer. And the information officer then must decide. He has a period of 2 weeks, 14 days to decide whether they will provide the information to you or not. It depends from institution to institution. Some institutions as a standard they refuse, saying they can't give it. But what is important is you can't just say I'm not giving it. You have to relate it to a basis in the act which says you can withhold the information. And what is relevant to you basically is this private information. They will have to say, well, this is private information, we can't give it. It doesn't stop there. If they give the information, well and good. If they don't give the information, you can appeal to the officer called the designated officer. That is also another officer in the institution. Now, for example, the UDA would have another person named as a designated officer. Usually it might be the Director General or someone senior. So you have to then submit an appeal to that gentleman or lady and appeal against the decision refusing to grant you information. There are also situations where some institutions don't reply. So you wait for that period of 2 weeks. If there is no reply, you don't need to wait. You can then submit an appeal to the designated officer and then seek his intervention on this. If that also fails, you can then, of course, you might have to consult lawyers, but then you can, of course, appeal within 2 months of that decision to the Right to Information Commission, which is situated at the BMICH. And I can say that the commission is very progressive. It's looking at, the need to release information. In fact, by law, one of the commission members is nominated by the Bar Association. Of course, doesn't represent us, but just a nominee. So it's not that the officer represents us, and the commission is independent. And then, of course, a lot of information in situations are provided. If that fails, one can then appeal to the Court of Appeal. So basically, that is the regime we have in respect of the right to information. I must reiterate why I thought of this topic. This is something you and me as citizens can make use of, and of course it's not limited to your professional work. We have dealings with public authorities all the time. And of course, another aspect which I must reiterate or emphasize is that this is a tool to hold public officers, public authorities accountable. And so the more we make use of this, we all have our complaints about sometimes what takes place, what some people do. But if we stay silent, then of course it will continue. This is a tool provided to the citizen, a simple tool in 2016 to make use of, and it's not difficult at all. So basically that is, I have a very detailed, comprehensive presentation on right to information, but that is for the different audience, lawyers. But I think that, so I hope in this short 25 minutes, I've been able to explain to you or bring your interest in something which is available to you, and also do try to make use of it whenever the need arises, because as they say, information is wealth, information is strength, because sometimes we are always groping in the dark because we don't have information. And this is something which has given us a tool, a mechanism to secure that information. So if there are any questions, I can take those before the conclusion of the presentation. And of course, you all have the opportunity, if you need advice, you can speak to a lawyer. And I'm just saying that you can, simple things you can make use of through this presentation. Anyway, thank you very much.